Good afternoon and welcome to this information session on the Hague Conference on Private International Law. My name is Christophe Bernasconi. I am the Secretary General of the Hague Conference, and it gives me great pleasure today to introduce to you in very general terms the organization as such, the type of work that we are doing, and how we are doing this type of work. At the outset, I would like to take the opportunity and wholeheartedly thank the organizers of this wonderful forum for having not just invited the Hague Conference again to attend, because we have been regular attendees of this forum, because we think it's a wonderful platform for dialogue and exchange of views and wonderful opportunity for networking. We are all the more grateful to the organizers as in past years they have given us this opportunity, this platform, this special session to present the work of the Hague Conference to you. So it is, of course, with great pleasure that I address you this afternoon. Now, one of the first things you might be actually quite intrigued about is I'm talking here about the Hague Conference, and then you see there on my title slide the HCCH. And you may wonder, why HCCH? What does it stand for? Well, let's get that problem solved right away. The Hague Conference has two official languages, English and French. In English, it's the Hague Conference on Private International Law, obviously. En français, c'est la Conférence de la Haye de droit international privé. Now, if you take the relevant letters of Hague Conference, Conférence de la Haye, you get to HCCH. Doesn't quite work in Russian, but that's where we are. Okay, so that's the first mystery solved. And if there is one thing you will remember of this presentation, it may be this, but I very much hope there will be many other things you will remember after the presentation. What is the Hague Conference on Private International Law? Well, it is an intergovernmental organization in its own rights. We are not an agency of the United Nations. We are not associated to any other intergovernmental organization. The Hague Conference is its own intergovernmental organization. And under Article 1 of our statute, the purpose of the Hague Conference is to work towards the progressive unification of the rules of private international law. Now, I keep using this term private international law. Let me just briefly explain what we mean by private international law. In a cross-border situation involving people from one state and people from another state who either engage in some sort of personal relationship, like getting married, or engage in a commercial activity, what have you, or if business entities get into a commercial relationship across borders, you typically have four basic questions that you are faced with. In a case of litigation, if something goes wrong with your relationship or your contract, the first basic question you will ask yourself is, well, which court has jurisdiction to hear the litigation arising out of our relationship? A question of jurisdiction. Which law will be applicable to this cross-border situation? Is it the law of the Russian Federation or the law of India, if both these states are connected? Or does maybe the law of the UK or Switzerland apply for whatever other reason? Once you have your judgment, the next question, of course, is, well, what can I do to have my judgment recognized and enforced in another jurisdiction, typically where assets of the judgment debtor are located? And finally, the fourth dimension of private international law, which is becoming more and more important, is this whole dimension of legal cooperation. Are there means in force between the states that would help you to overcome the challenges of, say, a cross-border international civil procedure? Can you rely on a cooperation mechanism, for example, to have service of process effected on a defendant in another state, or to take evidence in another state? So these are the four very basic questions of private international law that are at the very core of the work of the Hague Conference. Now, it is very important to keep in mind that all we do, all in quotation marks, is private international law. We do not deal with domestic substantive law. That is a big difference in the nature of the work between the Hague Conference and our sister organizations, such as UNCITRAL and UNIDROIT. They deal mostly with the unification of substantive law. We like to refer to the type of work that we are doing as road signals or traffic signs that tell you which way to go in a cross-border situation, to this or that court, to apply this or that law, or embark on this or that cooperation mechanism between states. We therefore build bridges across jurisdictions, but at the end, or at both ends of the bridge, we don't touch the substantive laws that is in force in the jurisdictions. The Hague Conference on Private International Law is in fact the oldest of all the organizations based in The Hague. And there are many of international legal organizations based in The Hague. The Hague Conference is the oldest one. Its origin goes back to 1893, when the first Hague Conference was held in The Hague. Now, this slide is an important slide because it shows the two main driving forces behind the first Hague Conference on Private International Law. I give you on the left Tobias Asser, and on the right, of course, Theodor Martens. Tobias Asser was a Dutch statesman, politician, who was involved in almost all of the international initiatives taken by the Dutch government at the end of the 19th century. And he was this driving force behind the first Hague Conference. He had this vision that these cross-border situations involving people or commercial entities are raising, of course, all sorts of private international questions. We knew that back then. But that there should be an international organization that tries to harmonize the rules that govern these cross-border situations. Theodor Martens heard about it and from the beginning on was very supportive of these initiatives. He came to The Hague and attended the first Hague Conference in 1893. In fact, he liked it so much that in 1894, when the second Hague Conference was held, he came back, again attended, and then for the third and fourth Hague Conference held in 1900 and 1904 respectively, Theodor Martens was actually the chair of the Hague Conference on Private International Law. So the history of the Hague Conference is very much linked to this great lawyer that Theodor Martens was, and I'm referring to him with a special mention today because I have been told that the Martens lectures are actually being held today and tomorrow here in St. Petersburg. Tobias Asser went on to receive the Peace Nobel Prize in 1911 for having established the Hague Conference on Private International Law. Fyodor Martens liked his experience in The Hague so much that he came back to St. Petersburg and suggested to the Emperor Nicholas II to hold the first peace conference in The Hague, which then happened in 1899. Fyodor Martens then was a runner-up nominee for the Peace Nobel Prize in 1902, I think it was. Now, I told you that the Hague Conference is the oldest of the international organizations in The Hague, but it's also the only one with a legislative function. We are not a court, we are not a tribunal. You cannot come to the Hague Conference and start enforcing your rights. You cannot start legal proceedings at the Hague Conference. No, our mandate is purely legislative. We develop legal rules in the form of private international law rules that then apply in these cross-border situations if the states involved have ratified or acceded to the famous Hague Conventions. Because the way in which we fulfill our mandate is by developing and adopting the famous Hague Conventions. They have been referred to in the early 70s already as world laws. World laws because some of our conventions are so widely ratified and used throughout the world that they have indeed become an international standard, a world law, if you want. There is a total of currently 38 of these Hague Conventions on the books. That includes 2 or 3 protocols and a recent first soft law instrument that the Hague Conference has developed in the field of international commercial contract law. And I will get back to this in a short moment. This map shows you the membership, the current membership of the Hague Conference on Private International Law. As we speak, we have 78 states that are members of the Hague Conference, plus 1 regional economic integration organization in the form of the European Union. The European Union, in addition to all its member states, is in its own right a member of the Hague Conference. There are 2 candidate states that are in the process of becoming a member, Andorra and Moldova. There are 2 other states that have been admitted but still need to accept the statute, that is Colombia and Lebanon, and all the other members or countries here in dark blue are actual members of the Hague Conference. Now, based on that slide, I never feel quite comfortable to say that the Hague Conference is a truly universal global organization, because you look at the map and you immediately see a gap. You see a gap in Africa, you see a gap in the Middle East, in some parts of Central Asia and other parts of Asia Pacific. And that is indeed where more work of the Hague Conference is needed to increase our visibility and to make the relevant authorities realize that these Hague Conventions are relevant for their legal framework that addresses these cross-border situations. I'm getting much more comfortable, however, when I show you the following slide, which is the slide that shows you that in fact there are 145 states around the world that are connected with the work of the Hague Conference. What does that mean? It means in essence that a state does not have to be a member of the organization to join one of our conventions. That's why we have 68, if my math is correct, other states that without being a member still benefit from the work of the Hague Conference because they have the good idea to join at least one of our conventions. I say it's a good idea. Typically so happens that when a state has been a party to one of our conventions or 2 or 3 of our conventions for some time, they get a nice letter from us, the Secretariat, inviting them to become a member of the organization and therefore also share a bit of the burden of the budget, of course. And we'll get back to the membership and the budget in a moment. But based on that slide, I do feel comfortable indeed to say that the Hague Conference is a truly global organization. The Hague Conference, of course, has its headquarters in The Hague, as the name suggests. But we have gone regional in the more recent past, and we opened a regional office of the Hague Conference in 2005 in Buenos Aires, and another one in Hong Kong in 2012. Why these regional offices? Well, because we are convinced that it is indeed important to be close to specific regions of this world to get a better understanding and feeling for the real needs of this region, to have someone from the region explaining our work to the lawyers of the region in their language, against the background of the legal systems that may be in place or that are in place in these relevant regions. And looking at the map, again, you can easily imagine where we at the Secretariat believe the next regional office should be opened in Africa. In Africa, a lot of work is needed, again, to increase our visibility. It is important to keep in mind when talking about the Hague Conference that in fact we have two main activities. One main statutory activity, of course, is all the normative work, the development of new Hague Conventions, or in the form of soft law, maybe. But in addition to this normative work, which is the traditional mandate of the Hague Conference, we have developed over the last years and decades quite a large expertise in the so-called post-convention services and the post-convention work that we do. So for normative work, what we mean, of course, is that we as the Secretariat, we are involved in the research that needs to be done to prepare the discussions on a new topic towards the possible development of a new convention. There are proposals for new conventions that can be made by the Secretariat, that of course can be made by the members of the organizations or indeed by other organizations. And then we as the Secretariat, we also support the actual negotiations, which most often would start at the level of experts in form of experts groups, and which are then brought to the more official, formal state negotiation level at a later stage. But the Secretariat, the Permanent Bureau as we call it, is very much supportive of all these different activities. But we also believe that it is one thing to put these conventions on the table, it's another thing to make sure that they actually work in practice. And for that to happen, of course, you first have to promote the instruments, explain the instruments to the relevant stakeholders, to government officials, to practitioners, to judges, to social workers, depending on who might be involved in the actual operation of these instruments. So we're talking about promotion, but we're also talking about monitoring. We do, to the extent possible, monitor the actual operation of our conventions, and we call for experts meetings on a regular basis to talk about the actual operation of existing conventions. We do a lot of publications, of course, to support these activities, to explain the essence and content of the conventions and help practitioners when they face questions or issues in the operation of the conventions. And then, that is a more recent activity, we also provide actual technical assistance. And that is post-convention service in the narrowest sense, because that is a real commitment to send an expert, say to Haiti, to Cambodia, to Nepal, for example, technical assistance for the implementation and operation of the Hague Adoption Convention, which is the one single convention that generates most of our technical assistance work. But these are more long-term projects where you really try to involve all the relevant actors in the operation of a convention to make sure that the instrument works properly on the field. Then if you look at the catalog of our conventions that are on the books, you can distinguish three main fields of activities or fields of normative work. The first pillar category of our work is all the work that relates to international protection of children. That is the first thing that many people think about when they think about the Hague Conference on Private International Law. There we have a series of very important conventions that have been adopted in the past. There is the Child Abduction Convention that is in force in 93 contracting states. You have the Inter-Country Adoption Convention, which is in force in more than 90 states. You have the Child Protection Convention, which very much complements the Abduction Convention. And you have a new convention, 2007 convention, on the effective recovery of child support abroad, a fairly recent convention which has already attracted more than 30 contracting states and which, in my opinion, clearly is the next big thing in the family law field of the Hague Conference, just because of the practical importance of the topic that it addresses. All of these conventions, again, core conventions of the Hague Conference, are based on a system of central authorities. Each contracting state designates a central authority, typically within the Ministry of Justice or Foreign Affairs, that is really in charge of operating the convention in the respective state, and to receive requests for the return of a child, for example, or to treat adoption requests, or to organize the effective recovery of maintenance obligations. The second important category of normative work of the Hague Conference relates to international civil procedure. There we have instruments such as the Service Convention, also how to serve process abroad, or how to transmit judicial and extrajudicial documents from the state of origin of the proceedings to the state where the defendant is typically, and how to effectively organize this transmission of documents to be served abroad. Interesting to note, then again, the actual service in the receiving state remains governed by the substantive law of the relevant state. The Hague Service Convention does not say how to effect service in the receiving state of jurisdiction. It's, again, a cooperation convention that establishes effective means of transmission of the documents to be served in the receiving state. The same goes for the taking of evidence abroad, or to guarantee effective access to justice. We have a new choice of court convention of 2005, which I will briefly talk about tomorrow on a panel on the recognition of foreign judgments. There you see that this convention on choice of court agreements currently has one contracting state, Mexico, but that figure will soon change, because the European Union, for the European Union, is about to approve this instrument, which will then enter into force for the European member states. And we believe that therefore this year is a very important year for the Choice of Court Convention, because it will really take off the ground and provide this legal certainty and predictability which you want in cross-border commercial situations, and where you want to rely on your selected forum. The third category of normative work would then relate to international commercial law and finance law, which is a slightly less prominent category of our work, but I can mention there the Trust Convention on the recognition of trust established abroad. There is the Securities Convention of 2006, which was the first real finance law topic developed by the Hague Conference, which was the first actually to be developed on the basis of full consensus. The Hague Conference operates on consensus since about the year 2000. No more votes are being taken at the Hague Conference. And you have the new 2015 principles on choice of law in international commercial contracts, the first soft law instrument developed by the Hague Conference, which is in essence designed to promote the idea of party autonomy in jurisdictions that do not know the concept or which apply it in a rather restrictive form. These principles, 12 principles of choice of law in international contracts, are the first very comprehensive or most comprehensive regime establishing the rules for effective choice of law in commercial contracts. And I would like to take this opportunity to thank our sister organization from UNCITRAL, because in a couple of weeks UNCITRAL will officially endorse these principles, which of course is like a stamp of approval for us and will greatly help us in the further promotion of these principles. So you know who we are, what we do, and then you may ask yourself, well, what then are actually the resulting benefits of the work of the Hague Conference, and what are the resulting benefits if you join one of these conventions? I always like to bring this down to two very specific points. The first point is that what we do at the end of the day facilitates cross-border trade, cross-border commerce, and foreign direct investment. Why? Well, because we have a number of these conventions that I have been referring to that are world laws, as has been said already, and which really establish international, if not global, standards that investors and parties involved in cross-border trade actually expect to be in force in a jurisdiction before they do business there. For them, this is very much part of legal certainty and predictability. So one can say that the Hague Conference and the Hague Conventions are an important aspect of the rule of law in cross-border situations. I can explain this on the basis of a specific example, for example, in relation to the Apostille Convention. The Apostille Convention is a convention that essentially greatly facilitates the production of public documents that have been prepared in one state and need to be produced in another state. Why am I mentioning this convention here? Well, first of all, it's the most successful of all the Hague Conventions, 108 contracting states, and we keep counting. But the World Bank Group, the IFC, the International Finance Corporation, uses the Apostille Convention to assess how attractive a jurisdiction is for foreign direct investment. A jurisdiction that is party to the Apostille Convention is more attractive for foreign direct investment than a jurisdiction that is not. Why? Because the Apostille Convention eliminates red tape, facilitates these formalities that need to be established when, or gone through when you want to establish a business presence in another jurisdiction. Same goes for the ICC, not the International Criminal Court, but the International Chamber of Commerce in Paris, which both supports both the Apostille and also the Choice of Court Convention, because again, they either facilitate the formalities or contribute to legal certainty and predictability. The other, you could also, yes, refer to the group of 30, which is an association of very senior people in the finance world, which soon after the adoption of the Securities Convention issued a recommendation that states shouldn't indeed join and sign up on the Hague Securities Convention. Again, a sort of a stamp of approval from the industry telling us, okay, what you have done works for us in the industry. It's not just an academic exercise, but we can actually implement what you have developed in The Hague. The second important benefit that results from the various Hague Conventions in the family law field and child protection field in particular is giving effect to human rights. And I think there is a very effective example to illustrate my point. And I refer here to the UN Convention on the Rights of the Child of 1989. All but 3 states of this globe are party to this very important convention in the field of protection of the rights of the child. You probably can't read this, but the UN Convention on the Rights of the Child has a whole series of very fundamental articles in the field of child protection. But they are very general articles. They, for example, say that a child should have the continuing right of access to both his or her parents. So even after a divorce of the parents, the child shall have access to both parents. It says that states should take measures for the effective recovery of maintenance obligations abroad. States should take measures to combat illicit trafficking of children. Cross-border adoptions should only take place in the best interest of a child, and so on and so forth. But there is no machinery in the UN Convention on the Protection of Children to actually give effect to these very fundamental principles. And this is where our conventions kick in. Our conventions which broadly relate to child protection in general. The Abduction Convention, the Adoption Convention, Maintenance Convention, or the Child Protection Convention. So by becoming a party to these conventions, the state actually does give effect to the principles the state signed up to in form of the UN Convention on the Rights of the Child. So far I have been talking about the work on the books, or the conventions on the books, but what is in the pipeline? What is under preparation? Well, we have 2 priority projects that have been identified by our Council on General Affairs and Policy recently. One relates to judgments, referred to as the Judgments Project. In essence, what we are trying to do is to develop for the first time a global regime for the recognition and enforcement of judgments in civil and commercial matters. Something that Tobias Asser already dreamed about. So you see, when you do this type of work, you have to be patient. It takes time to work on such sensitive topics. But I think we are at a stage where time may be right for a comprehensive convention on the recognition and enforcement of judgments. The more tricky element of this project is to what extent should the convention also deal with direct grounds of jurisdiction? That is a slightly more challenging aspect, and we'll see what the experts will say on this. You may know, some of you may know, that we gave it already one shot 15 years ago on this topic of jurisdiction and the recognition and enforcement of judgments. Back then, the efforts did not succeed in a comprehensive convention, but these efforts led then to the Choice of Court Convention that I have been referring to before. So the Choice of Court Convention is a spin-off result of the initial work on the Judgments Project, but now the Judgments Project is back on track, but with a specific emphasis, at this stage at least, on the recognition and enforcement of judgments. This is ongoing work, and we'll say a few more words about this again at tomorrow's panel on the recognition of judgments. The other main topic relates to family law, again child protection, and relates to a very sensitive matter, in particular to this growing phenomenon which is surrogacy, where parents or adults who cannot have children on their own enter into a contractual arrangement with a surrogate mother, often in another jurisdiction, to have a child born for them. Now, one may think whatever you want about these arrangements, but at the end of the day, you have a child born in those circumstances, and you want to know what is the legal status of this child? What about the filiation rights of this child? And that is why the Council has mandated the Permanent Bureau to organize an experts group on this very topic, which will start its work probably in the course of this year or early next year. Then we have another topic, which is the recognition and enforcement of foreign civil protection orders. Again, this is work that has already started to some extent at the experts level, but we are still exploring whether or not there is enough practical issues really that need to be addressed in form of a legal instrument. Same goes for the recognition and enforcement of voluntary cross-border agreements. So there we are particularly talking about mediated agreements in family law situations. Is there a need for an instrument, the Hague Convention possibly, that would facilitate the recognition abroad of mediated agreements, which very often deal with a series of different aspects of the situation that may arise after a divorce, be it custody rights, visitation rights, and other rights. And so maybe there is a need for a global instrument on the recognition of such agreements. Then our Brazilian colleagues suggested a few years ago already a topic that relates to the protection of tourists. People who go abroad or visit foreign jurisdictions normally would have a good time, but sometimes stuff happens and you are caught in whatever situation in which you may need to have access to information, access to effective help and assistance in your language to help and enforce your rights. The Council this year has revisited this topic again, has been supported by a number of other states, and we will do a feasibility study on this topic in the coming months. And finally, last but not least, one of our important conventions in the field of civil procedure I've mentioned is the Taking of Evidence Convention. There is general consensus that you can use this convention also to take evidence in electronic form by video conference in particular. So you have a judge in jurisdiction A taking evidence or supervising a session of taking evidence in another jurisdiction. You can do that by means of video link connection. Obviously, this is already done in a number of jurisdictions, but the question is, do we need a protocol or maybe another instrument that would effectively support these developments so as to ensure the sound use of modern technology in those circumstances? Then, finally, a few words about the membership process. I'm adding these slides because when I gave a similar presentation last year, I had ministers of countries that are not yet member of the Hague Conference who said, we are interested, we would like to join, but how do we do that? Well, here is how you do it. Typically, the head of the government of the state in question would send a short letter to the Minister of Foreign Affairs of the Netherlands, simply asking to be admitted as a member of the Hague Conference. The minister then, the following day, typically, would send me as the Secretary General a letter saying that the Dutch government officially proposes State X as a new member of the organization. I then open a 6-month voting period on the admission of the state in question, which typically is a pure formality. At the end of the 6-month period, we establish un procès verbal, which establishes that the majority of the votes cast are in favor of the admission, and then the ball is back in the court of the interested state, because after the 6-month period, and once we have established the procès verbal, the state is invited to deposit its instrument of acceptance of our statute, and then on that day the state becomes a member of the Hague Conference. I have had the pleasure and the privilege of being with the Hague Conference now for almost 17 years. It's really heartening to see that in that time the number of members has almost doubled. And it clearly shows that the work of the Hague Conference is more relevant than ever, because more and more often stuff we do, relationships we enter into, be it at the personal level or on the business side of things, do have a cross-border element. And in all these situations, you are faced with a private international question, as explained at the opening, and you want to know what the regime is that applies in those circumstances. What are the benefits of membership? Well, you become a member, you become part of a club, of the only organization that addresses these crucial and often very practical cross-border issues at global level. There is no other Hague Conference, there is no competitor, if you want, that develops legal instruments at the global level to address these particular issues. And our instruments at the end of the day, as I've said, are for the benefit of people and business entities. I like to say whenever I have a visitor coming to the office that every single day when I cross the door to my office, I am deeply motivated by the fact that our instruments at the end of the day do make a difference in people's life. That can be people who are getting married or divorced across borders, but it can also be for people who have to show their public diploma in another state and benefit from something as straightforward as the Apostille Convention, which is used millions and millions and millions of times a year. So you do feel that at the end of the day you can make a difference in people's life, and that is very heartening and an excellent source of motivation, of course. Some have referred to the Hague Conference therefore as the only world organization for cross-border cooperation in civil and commercial matters, which is a leitmotif that is on our website. As a member, of course, you can co-determine the work program of the organization. That goes without saying. You are invited to all official gatherings and meetings of the Hague Conference, including the council that decides the work program. Practically speaking, probably the most significant advantage of being a member of the Hague Conference is that you have priority access to technical assistance. We are receiving so many requests for technical assistance that we have to prioritize them one way or another. And one way, effective way of doing so is to say, well, we serve members before we serve non-members, which I think is a very legitimate position to take, obviously. And we have to do this all the more as the budget of the organization is a fairly limited budget. The Hague Conference is a small organization with a very proud and efficient staff. We are only about 30 people in the Secretariat. And a handful of colleagues in Buenos Aires and Hong Kong. The budget of the organization is about 3.8 million euro. I am sure that if the Hague Conference did not exist and someone came, you know, a new Arthur, a new Martens came with the idea, oh, all this cross-border business and all these cross-border relations, surely we need an intergovernmental organization that looks after these issues and develops rules that apply in those circumstances. If that visionary came up today with the idea, I'm sure that the Hague Conference would be a much bigger organization. But being small also has advantages, very specific advantages. We are very flexible. Our lines of communications are very short, and I think that makes us a very efficient organization indeed. As a member, and that's important to stress, there is no obligation to join specific conventions. In fact, no member, there is not a single member of the Hague Conference that is a party to everything. The champions like the Netherlands, France, and a few others are maybe party to 30 or so conventions. But there is a core of about 12 to 15 conventions that we like to identify, the ones that form these three categories that I have been mentioning before. These form the very core of our work, and we do encourage members to become a party to these specific conventions. But at the end of the day, it's always the choice of the state, of course. There is no obligation to join this or that convention. And as I said already, given the budget of the organization, 3.8 million, 79 members, you can imagine that the individual contribution of a state is not that high. Our biggest payers, 6 biggest payers, each pay about 200,000 euro to the budget of the organization. And for all the others, it's decreasing proportionally. So you can see that the financial burden is fairly modest. On this happy note, I am pleased to end my overview of the work of the Hague Conference. Again, an organization that is linked in quite some significant ways also with the beautiful city of St. Petersburg through the very important presence of Martens at the very early stages of the work. It gives us every year great pleasure to come back to this wonderful forum, to meet new colleagues and build new bridges with other jurisdictions. I'm happy to take questions now or informally during the break, but in the meantime, I wish to thank you for your attendance and for your interest in the work of the Hague Conference. Spasiba. There doesn't seem to be a moderator of this session, so what I'm going to do is just stay here in the corner for a while, and if you have questions, please feel free to come and see me. I also have a few documents with me that I'm happy to share with you if you want, and the presentation will be made available online. Thank you.